Hi there, I'm Miko Nehman. I'm with Century 21 Hometown Realty.
And I'm April Hugh. I'm with Century 21 Hometown Realty. And today we have a special guest, Aaron Smith, attorney, specializes in estate planning and trust litigation. Welcome, Aaron.
Thank you. It's great to be here. My practice focuses on estate planning, and I've been doing this for 17 years and enjoy doing what I do.
And where are you located?
I'm located in Old Orchid, right above Blast, and Blast 825, so it's kind of convenient for lunch meetings. Yes. I've been there since 2014. Before that, I was over off of Barcelos in Santa Maria. So I've been in Santa Maria my whole practice.
Okay.
That's nice.
So 17. Okay, and most of your clients are local clients, or do you have...
I would say a majority of my clients are, Santa Maria, Orchid, Napomo. I do have some clients in San Luis and Arroyo Grande, and then I live in Los Alamos, so I do have some clients there that I see. They don't want to drive all the way here, so I meet them, in Los Alamos and San Ynez, that area.
So then most people, if you have a property or what would be the baseline to establish a trust?
Really, the general baseline is anytime you own real property, you should have a trust. Because if you don't have a trust and you say you just have a will, and your will says, let's say you have 2 kids, and your will says everything I have goes to my 2 kids when I pass away. Right. Well, it will eventually go to your 2 kids, but it will have to go through probate. Right. And so to avoid that, you create a trust, and that takes care of it.
Is there ever a time when you would have a trust over a will or the other way around?
When you own real estate, you will have a trust. You should have a trust. Okay? When you have a trust, you also have a will. And you have both because when you have a trust, there are certain assets that you don't put in the trust right away. So when you form your trust, you put your house in the trust, obviously, and some brokerage accounts and things like that. But typically you don't put like vehicles in a trust, maybe some small checking accounts, your everyday checking. And for those items, your will would control those. And when you have a trust, your will is called a pour-over will. And it's called a pour-over will because it just says, when I die, anything not in my trust gets poured over into my trust and distributed according to the terms of my trust. So that covers things like the small checking accounts and the vehicles that might not be in the trust.
Okay. So can you explain the difference between revocable trust and irrevocable trust?
Yeah, so most people will have a revocable trust. And a revocable trust is a trust that can be either amended or revoked by the settlor. The settlor is the person who has created this trust. Okay, so during this person's lifetime, as long as they have capacity, they can revoke or amend this trust at any time. Most people want to have that level of control over their trust. There are very few times when an irrevocable trust is recommended. Things like maybe to save on estate planning or estate taxes, to avoid creditors, or to maybe qualify for government benefits. Those are the only 3 times really that you will even consider having an irrevocable trust. So most people have a revocable trust.
Okay. Yeah, because I've seen those, in some of the titles, and I have always said, gosh, what is the difference? What's the benefit? But
now there is, so that brings up another, so you probably do see, sometimes on titles it'll say something like the Aaron Smith Family Trust B, and that trust is irrevocable. But that's a little bit different because what happens is a married couple sometimes have what's called an A-B trust, and when one spouse dies, the assets in the trust get split into 2 separate trusts. One trust is an A trust, and the survivor can do whatever he or she wants to do with those assets, The B trust is irrevocable. And the purpose of that, one is to save on estate taxes, and the other one is if you have blended families, where you want to make sure that the surviving spouse can't change the beneficiaries on the part of the assets. So sometimes that's when you see an irrevocable trust too in real estate.
Okay.
Have you ever seen a trust where the people put their property in the trust and it's a rental property, and then they're able to avoid capital gains when they go to sell it? Like a something to do with like a corporation
Or LLC.
or something like that.
So, I mean, anytime, often I get people who are getting old and want to just gift their property to their kids while they're alive. Most of the time, that is not recommended because if you inherit property, it gets a step up in basis for capital gains tax. So it's always better to inherit it. Whereas if you gift property, whether you gift it in an LLC or a corporation or however you want to gift it, it keeps the same tax basis as the person who gifted it, as the donor. And so you really, you would be paying a lot more in capital gains if you were gifted it while you're alive, an inter vivos gift, versus if you were to inherit it.
Okay.
Okay. So.
And let me just go back. So when you own real property, a trust is the recommended mechanism to transfer that upon death. There is something, and I can't remember the year, it was 3 or 4 years ago, that the California legislature created called a transfer on death deed. You probably don't see it very often, but it's out there and not many people know about it. And so that's one way, when I get that a lot is if someone is on their deathbed and there's no time to create a trust, and they have one child, and so what we do is we can create a transfer on death deed. And essentially what it is it's like a brokerage account that has a payable on death beneficiary, but it's a deed, and the deed says when I die, the property will go to my child so-and-so. And so that's another way to do it. It's not nearly as flexible as a trust, but it is another mechanism to avoid probate and have your property not be transferred until death.
Now, what about if you have multiple bank accounts and then you set it up with the bank and you say, I want to do a pay upon death to my beneficiary? Does that supersede the trust?
100%, yes. Yes,
Okay.
100%.
You say that again?
Okay, so you can take your bank accounts and you can go into the bank and fill out a form,
Okay.
and you tell the bank that when I die, my bank account goes to this person. Okay.
And you have that, you can do any time do
Yep.
that?
Yep.
Okay.
I have it
Okay.
all done with all my accounts. And then I have it done with my mom's account so that when my mom goes, that it goes to me automatically.
And that works well unless you have, say you have 2 kids and it's your desire that if one of your kids dies, their share goes to their kids. And if you just have payable on death beneficiaries, a lot of the time, if one of those beneficiaries dies before you, everything goes to the other one. Instead of, 50%
Putting it into the
going to
trust
one
and then,
going to the
yeah.
kids. So it works well, especially if you only have one kid. If you have 2 children, and one of them were to predecease you, then you would want to go and change the beneficiaries on the bank accounts. But yeah, it's a good, but that does trump a trust. That trumps everything. A payable on death beneficiary, for the most part, trumps everything.
So for example, I have a property and I own 99% of it, and someone else owns 1%, right? So now if I wanted to create a trust for that property, and then I own another property that I split equally with my husband. So if I wanted to have a trust, am I able to do that to where my 99% is only in that.
Absolutely.
So you can be real specific, right?
Yeah, you can be as specific. I mean, you can be as general as you want. So let's say the property that you own 99% of. Really, all you'd have to do is create a trust, do a trust transfer deed saying I transfer my interest in this real property to the trust, and record that, and your 99% is now in the trust. Now, what you have to be careful of when you do that is if you hold title as joint tenant with that other one, well, I guess you wouldn't, because you would, as joint tenants, you have to own it equally. But one of the things you want to be careful of is if you do own property, like let's say you're partners with a brother or sister or a friend and you're 50-50 owners and you hold it as joint tenants, meaning with a right of survivorship, so that when one of you passes away, it goes to the other one. Well, if you create a trust and put your 50% in the trust, that severs the joint tenancy. And so the individual now who doesn't have a trust, who is a 50% owner, would own it as tenants in common. And if he or she were to die, then her 50% interest would have to go through probate.
Okay, interesting. Okay, that's in, yeah.
Yeah. So one year, my mom and I and my son all decided to get on a plane, and I went, oh my gosh, I need a trust. So I went and did an online trust, because I thought everybody that is going to get anything is going to be on the plane with me.
Sure.
So then, what do you suggest that people avoid doing that? But
Well,
plan ahead, right?
Absolutely. I mean, I can't tell you how many people call because their mom or dad is in the hospital or on hospice and they only have a couple weeks to live, and it's the saddest story. And usually at that point, it's too late. And because a lot of times if they only have a couple weeks to live, there's a lack of capacity, especially if they're only planning to give their assets to one child. If they have multiple children and they're in the hospital and it's a kind of a last ditch deal that they want to just make this real quick, it really doesn't. It would be subject to undue influence, and so you have to be very careful about that. So plan ahead. It's really not that difficult to do a trust. I mean, I try to make it as simple as possible, and I try to make it so that people understand what they're reading, what their trust says. Because if they don't understand it, it doesn't do any good.
So do you just hand them a questionnaire and just go, tell me what you own?
Absolutely. It's a 6-page questionnaire. Yep. And the first page is just your, familial information, your kids' names, your spouse's name, dates of birth, if they have children, if they're married, single. And then the next 4 pages are all their financials, their IRAs, their retirement accounts, their 401ks, their bank accounts, brokerage accounts. I mean, everything they own, because their interest in LLCs, their interest in corporations, all those things, because it's really important that those things be part of the trust. Right. Not necessarily retirement accounts or 401ks, those stay outside of the trust, but most of the other stuff should be in the trust.
Yeah. Okay. So my mom did a trust way back in 1996. And then before, she got bad, I took her into the attorney's office and I said, I want the trust reviewed. And lo and behold, there was a clause in her 1996-year-old trust that said that if she became incapacitated, then I would have to step up and I'd have to go to court, basically, to take control of things.
That's unusual.
Yeah, so we got that changed, and it was right before, she's got, some memory issues, so it was right before all that took place.
Wow.
And I was so thankful. Yeah, thankful that I had that reviewed, because I thought, go to court and try to get that turned, no.
Yeah, that is not common. Usually it's determination of incapacity is by a physician or 2 physicians who would.
That's what she changed it to. The attorney changed it to, that's all it would take is a doctor's information, a form, basically. So.
Yeah, And that's
I've learned the hard way
Yes.
on a lot of
And
stuff.
a lot of people do. You know, but those are actually some of the most fun people to work with, because people who have had to deal with their parents' trust or administer their parents' trust after their parents die, those are the people that come in and are like, I need a trust. And because they understand it more, you know, it's not some just thing that they've heard of that they have no clue about. And so that's when they come in and say, I need to do a trust.
So if you fail to do all this and you have no will, and does it automatically go to the state of California?
No, absolutely not.
Okay, because that was the talk years ago that
Yeah, it's, yeah, right.
That's called as cheating. ESCHEAT. Yeah. And
reading about that.
yeah, and that God, in my 17 years, I think I've only seen that happen once. I mean, you have to have pretty much no family or anything. So let's say someone does die, they own real estate, and they don't have a will, they don't have a trust. It has to go through probate. So it's anytime there's a house in an individual's name and it's not held in joint tenancy and they die, it will have to go through probate.
So can you explain probate then?
Probate is a court procedure where the court oversees, so you open up a case and the court oversees the administration of the estate. So somebody, usually it's a child, if it's not a child, it's whoever the beneficiary would be, and they would file this action in court and petition to be the personal representative of the estate. If there's a will, that personal representative is called an executor. And if there's no will, that personal representative is called an administrator. Okay, so once that person gets appointed as the executor or the administrator, and we'll just call it personal representative, then you have to provide notice to all the creditors. And so, you know, you can monitor the decedent's mail or go through their belongings and find out if they have any creditors. And the personal representative is legally obligated to notify them. Then creditors have to file, before the personal representative is required to pay them, they have to file what's called a creditor's claim. And so the probate, once someone is appointed as the personal representative, has to be open for 4 months. Okay? And in that 4 months, if they own let's say, and this happens a lot where the only asset they really own, you know, they have a small checking account, but the only other asset they own is the house. And so that can be sold within the probate. Once that person is appointed as the personal representative, he or she can sell the house. And then the funds would go into an estate bank account. And then once that 4 months is up, they can petition for final distribution. And that's when you get an order allowing the funds to be distributed.
Okay.
So it's typically, you know, even on a simple probate, I would say, depending upon the court, Santa Barbara County is really good. They're quick. San Luis Obispo County, their hearings tend to be a little further out. So you're talking between 8 months to a year for this to occur. And the reason, and so that's one of the reasons why you want to avoid probate, obviously, because it's so long, but it's also expensive. You know, you're talking between, I mean, depending upon the size of the estate, for just a basic estate, you're probably talking about $10,000 to $12,000, and then if your estate is more than $1 million, you're talking $20,000.
So what's the cost of an actual to drop a trust then?
It really depends.
So let's say it's just a basic, you have a house and a couple checking accounts.
So I charge $1,750 for a single person trust and $2,000 for a married couple. If you go to Santa Barbara, they charge about $2,500 for the same trust. So it really depends on where you live, but usually that's what it costs. So it's a lot cheaper
Than the will, than going the probate, yeah.
And then what about, and then the will, is that a cost involved with that?
So a will is only about $400, but the thing about a will is, if you just have a will, that will's going to have to go through the same process of probate, where the court approves the will, looks at the will, sees that it meets all the formalities, it's been witnessed by two disinterested people, and then the judge approves it, but it still has to be kept open for 8 months to a year.
Okay,
So it still has to go through that same process. There are times, though, that a will is all you need because, let's say you just have a few bank accounts and you don't, you rent a house. And so you just have a few bank accounts, and those bank accounts are the magic number, not counting real estate. So let's say you have liquid assets in a bank account, and cumulatively they're over $166,250.
Very specific.
That's the magic number.
Yeah, it used to be 150,000, and that everyone could remember, and somehow, the number crunchers in the back room decided this is a number that should work. So, so that's the magic number now. So, if a person who dies has over $166,250, and they don't have beneficiaries named,
Okay.
those assets are going to have to be probated. So that's the magic number.
Oh, so you better have 166,049, 249.
No, I've had it very close like that, yeah. And it's the date of death value. So, on the date of death, if you have a brokerage account worth 166,240, 280, and it drops after the person dies, you still have to go through probate because it's date of death
That
value.
is just crazy. So now back to the probate, and I remember, seeing it, court confirmation or not court confirmation.
Yes.
Yeah.
So what's that?
Okay, so most of the time, it is no court confirmation is required because the petitioner or the personal representative the judge has allowed them to administer the estate under the Independent Administration of Estates Act, and so there's not as much court involvement. What they have to do is when the house gets sold in probate, once escrow opens, you have to prepare a notice of proposed action, okay? And all the beneficiaries essentially have to be provided with this notice. And this notice provides them with the terms of the sale, okay? And if anyone objects to the terms of those sale, they have 15 days to object.
Okay.
And if no one objects, then they're deemed to have consented to the sale, and escrow will allow it to go through at that point.
Okay.
If they do object, then they can petition the court to stop the sale, and then court confirmation is required. But most of the time, court confirmation is not required.
Okay.
Okay.
It's kind of like that at a wedding. It's like, anyone here opposed?
That's right. That's right. And if you don't hear anything, you're good.
Yeah. Okay.
All right.
Okay.
Good. All right.
And isn't there something in the contract that talks about like overbidding or?
That's if court confirmation is required. Yeah, and then people go to the court. I think I've only done that once in my 17 years. It just doesn't happen very often.
Okay. That's good to know.
Yeah, I mean, I sell a lot of real estate through probates, and most of them are just as smooth as a typical sale would be.
Yeah. Okay. Yeah. Great.
Good to know. All right.
Great information. Thank you so much. Yeah.
Thank you for having me.
Yeah.
Yeah. Is there anything else that you can think of that might be helpful for someone that is deciding
On which, yeah.
The general rule of thumb is if you own real estate, you need a trust.
Okay.
I mean, that's the biggest thing, and it's not difficult to create one. It really isn't, and in the broad scheme of things, it's not that expensive either.
Okay.
So that's probably the biggest thing I can add.
Well,
Great.
you've motivated me. I mean, I don't have a trust.
Uh-oh.
What's your number, Aaron?
I know. Yeah. So, yeah, you'll be hearing from me for sure. And yeah.
It's really important, and I'm still getting my brother to create one. So it's just one of those things that people put on the back burner, And, you know, like I said before, a lot of people don't even pay attention until it's too late. And then their kids have to, or their beneficiaries have to deal with it in court. And no one wants that.
No, they don't. So, yeah.
No. Well, thank you for the great information.
You're welcome.
And if you have any further questions, I can be reached at 805-714-8124.
And my number is 805-878-5056. Thanks for watching.
See you soon.
Yeah.